Our final category tonight is Township Small Claims Courts. The Small Claims Courts allows every citizen to bring a small lawsuit in an informal manner, and it does not require a party to hire an attorney. The Small Claims Courts were created so that you would have a speedy and reasonably inexpensive, uncomplicated means of the determination of your claim. Tonight we'll first hear from Wayne Township Small Claims Court Democratic Challenger Gerald Coleman. Mr. Coleman.
Thank you, and good to see you all here. Thank you for staying with us this evening. My name is Gerald Coleman. I am the Democratic candidate for Wayne Township Small Claims Court. I have been an attorney for 22 years. I spent 9 of those years in state government, the remaining years in private practice. Over the past 9 years, I've had my own law firm, Coleman Stevenson, where we maintain a civil practice. I also have a small claims practice. I'm also a registered nurse, and I'm also an elder in our church, a local church. I'm also a family man. I have 2 daddy's girls, 16 and 14, and a lovely wife. Now, over the past several months, you've heard a lot of discussion. And if you read the papers, some of this has been on the news also about the small claims court, the issues that have been found in the small claims courts. This is because in 2012, the Supreme Court had a task force on small claims courts and issued its findings. And I'll just give you a few of those findings. It found a number of issues. It found that, for example, the individuals who went to court had no idea what their rights were. It found that individuals frequently felt intimidated by going into court. It found that at times poor individuals paid fees that they should not have paid. It found that at times creditor attorneys had access to files that individuals did not have. So as a result of these issues, the Supreme Court issued a number of rules. And the first set of those rules came out in March of 2013 and again in January 2014. And what these rules were designed to do was to equalize the courts and make it more user-friendly for those individuals who are not used to going into court. Frankly, those rules have improved the system, but there is room for a lot more improvement. For example, we need to create a better environment for individuals to settle cases. Many individuals who go to court have no concept of what settlement is. We need to encourage parties to settle cases. But in order to do that, we need to educate people on what is settlement and how to settle, what are the pros and cons of settlement, and what settlement is and what it is not. Many individuals have no idea, no concept. They think that maybe they have to accept what is being offered. Another thing we need to do is we need to ensure that small claims judges have an opportunity to share ideas. You know, I do a lot of practice in small claims court, and I can tell you, no 2 small claims courts are alike. They do things differently. And the small claims judges ought to get together and share ideas. And that should include the office manager, because they're the ones that set up the processes in the courts. And there are good ideas that need to be shared. And you will find when you start talking and start sharing ideas, it makes the court much more efficient. And another very, very important thing definitely has to be done is educating individuals on how to either bring or defend a small claims case. As I mentioned, I do have a small claims practice, and I see a lot of terrified people that come into small claims court. They have no idea what to do or how to do it. We can easily do a better job of educating individuals on how to bring and how to defend a case. There are several things we can do. We could have an educational forum. These hearings are typically set out about 30 days out. You could have once a month an education forum just to take 30 minutes to explain to people what to expect. We can give out an informational sheet on how to present a case in small claims. It would make the court much more efficient if individuals were better educated on how to bring a case to court. And it would make the system much user-friendly for individuals. In my last minute here, I want to share with you, I've had an opportunity to knock on a lot of doors over the past few months, and the one thing that I hear from individuals, what is the one thing you want out of court? And they tell me this: they simply want to be heard. That is a reasonable request. That is a reasonable thing to ask for, a very simple thing, yet That is something that a small claims judge has authority over. And I'm going to tell you about something I learned a long time ago when I was in state government, a very powerful lesson about public service. I had the opportunity to work in a policy position, and I made decisions that impacted hundreds of individuals. And I learned a very, very powerful lesson about authority. Authority without humility leads to arrogance and presumption. And so I have a little quote I keep on my campaign materials, and it simply says this: I will make sure you are heard. I will make sure you are heard, and I will serve with humility. That is my commitment, and I would appreciate your consideration on November 4th.
Mr. Coleman, thank you. In those same news reports that you referred to, it seemed that the scales, the balance of justice was severely tilted toward the plaintiffs' attorneys, and particularly the credit collection people. What would you do to alleviate that issue and rebalance the scales of justice?
That's a good question. When the Supreme Court passed the rules in March and again in January, that was the attempt to equalize. And those rules have actually improved, because what we had before was a system where individuals, creditors' attorneys, were picking the farthest court they could possibly go to and filing there. And these courts were far away from where a transaction took place. So the chances were individuals were not going to go to that court, particularly if they did not have transportation to get there. So individuals ended up with default judgments against them. So the rules were designed to address that, and they in fact did, because in certain courts, for example, Decatur, the filings decreased some 71%. And that should tell you something. In other courts, the filings decreased significantly. So it has improved. But as I mentioned before, there are things that can be done. One of the main things that needs to be done really is education. We can do a much better job of educating individuals about what small claims court is, how to utilize the system properly so it works for them. That will certainly make the court much more efficient. We need to do a much better job educating individuals on, again, how to bring a small claims case or how to defend it. Education is going to help make the system better. Education is going to help make the system more user-friendly for these individuals.
Thank you. Any questions from our floor? I don't see or hear any. Any last closing comment?
Last comment. I would invite you to go to my website, Gerald Coleman 4, that's the number 4, judge.com. On that website, there's a video, and it has some information about my life story. I'd like you to please go ahead to that website and take a look at that. It'll give you more information about me. And people who have seen that video have told me they were touched by the story, so I'd appreciate if you take that opportunity in that time. Thank you very much.